Paul Quinn.
Thank you, Mr. Speaker. And can I say that I rise to the invitation that has been extended me from the opposition by numerous speakers. We've just heard Raymond challenging me, and Jacinda, of course, is looking forward to my contribution on a couple of specific issues that she laid the taki she brought to the table, and I'm pleased that she has shown the courtesy to stay and listen to my responses. But I thought I might start with Carol Beaumont, who seemed to complain, and Raymond did sort of pick the theory up about this whole urgency thing. And Carol, young Carol...
Order. Full name. Must use the full name.
I'm sorry. So is it young, middle... Oh, Carol Beaumont. I'm not quite sure. Anyway, Carol Beaumont. Okay. Carol Beaumont sort of attacked the bill, notwithstanding that she did say that that the opposition was going to support the bill. She did attack it because it was small, and that by inference it was an unimportant bill. Well, I really need to take it down to the rugby field and start teaching her some of the simple things in life, like the KISS principle. Keep it simple, which is a issue that the opposition have great difficulty with. They seem to think. You need to speak for a whole minute. Yeah, they seem to think that that the bigger, the more voluminous, the more airy something is, the greater the content. Well, this bill, I agree, it is a smaller bill. Let me just check. 12 pages. 12 pages. But it is a very important bill. It's a very important bill. And we should not, and as the saying goes, we should not judge a book by the colour or title of its cover. And the same in terms of this bill. This is a very important bill, and while small, it is another step forward in the commitment that this government has made to improving law and order and justice to this society. And I want to start in respect of the bill specifically to canvass on a couple of things. And firstly, the first part of the bill is around the jury lists and the fact that in this bill, this government intends to ensure that the George Baker incidents can never happen again, where a convict of 70-odd convictions, who had in excess of 70-odd convictions, and you may well laugh, Miss Chadwick, but I think it's a serious issue that George Baker attacked in the back of a van Liam Ashley, and that's the case we're talking about here. And then, when defending himself, he was entitled to look at the jury list, and then went about ringing up one of the jurors and threatening. And the sad reality of life, as I know Kelvin Davis will know, is that most of these people that do this sort of thing have gang affiliations, and they get all their mates in Black Power, Mongrel Mob, or whoever it is to actually go out and threaten juries. Yeah, and for your information, Grant, actually, I do have relations in the Black Power. In fact, I have a brother-in-law in the Black Power, and he's a nice chap. So I don't shy away from that. So, but the fact of the matter is, these are the sorts of people that, in fact, use these intimidating tactics, and this bill is aimed at ensuring this never happens again. And as an additional protection, the only people that will be allowed under this bill to cite the jury list will be the prosecutor, a defence lawyer, or a court-appointed advisor to an accused, but not the accused himself. And if any of those people that have access to that jury list, Mr. Speaker, pass on information that will lead to someone contacting the juror, then they commit a serious offence of contempt to the court. And I know, Raymond, we're finally on the same wavelength. We're talking the same language, and this is great. I now want to turn to the issue that Jacinda Ardern, Miss Jacinda Ardern, the list member for Hamilton, that challenged me with about the issue of age. And 15A2. I didn't actually want to call Carol stupid. So I'm glad you have. Thank you for that. No. 15A2, Jacinda, and the operative words here are if that person chooses. So the onus. The actual prerogative is on the person themselves. It provides an out. Now, let me tell you, I've actually had the privilege of being summoned to do jury service twice, and it has been a great sadness to me that I unfortunately, on both occasions, I have not been able to do my civic duty in attending to the issue, and I've had to opt out because I think on both occasions actually I was travelling overseas, so I had to get a dispensation. In the same way, if a person of 65 years or more, got Nathan's here? Oh, good. If a person of 65 years or more wishes to opt out, then I believe that that's a very good clause. And so with those few comments, Mr. Speaker, I look forward to having the Law and Order Select Committee consider this bill and report back.
Order. This debate is concluded. The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Juries Service and Protection of Particulars of Jury List Information Amendment Bill, first reading.
The Honourable John Carter.
Mr. Speaker, I move that the Jury Service and Protection of Particulars of Jury List Information Bill be referred to the Law and Order Committee for consideration, and that the committee report finally to the House on or before the 8th of August 2011, and that the committee have authority to meet at any time while the House is sitting, except during oral questions, during any evening on a day on which there has been a sitting of the House, and on a Friday in a week in which there has been a sitting of the House, despite Standing Orders 187 and 190, 1B and C.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. Call on Government Order